What's up, everybody? Welcome back in to another episode of The Lawyer You Know. And we're going to go through some of the most recent documents filed by the defense and some by the Commonwealth. We get some more information about exactly what's going on and how all these video clips are coming out, what we think might be testified to in the future to try and help the jury understand why they're in the mess that they're in. And spoiler alert, it really doesn't look good for the Commonwealth. And I'm not sure how they give answers that make any sense. Will it matter to this second jury? I don't know. But let's dig into the new information we got today. All right. So there's a number of different documents. We'll get to as many as we can in today's video. But the first one we're going to look at is the defendant's motion for reconsideration of portion of February 18th, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the January 29, 2022 video surveillance footage in law enforcement custody. Now comes the defendant, Karen Reed, and respectfully requests that this court reconsider the portion of its February 18th, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. In denying defendant's request for the metadata underlying these critical videos in law enforcement custody, the court indicated that there is no affidavit of an expert or any evidence before the court that the procedure agreed to by skilled counsel for both parties would result in the destruction of metadata. In light of the court's ruling, the defendant submits the supplemental affidavit of defense expert Matthew Erickson, which establishes that the procedure proposed by the Commonwealth and ordered by the court will result in destruction of relevant metadata that is critical to Ms. Reed's defense and is necessary in order to verify the authenticity of any additional Canton Police Department video surveillance footage that are produced in connection with this case. Okay, so basically, the defense is saying, all right, Judge, you said we need an affidavit. You said we need more information to explain to you why the process needs to be what the process needs to be. Well, here's your affidavit. And here's more information coming from the Commonwealth that lets you know exactly why this is all necessary. As the court aptly recognized, pursuant to Massachusetts Rule of Criminal Procedure 14b, the prosecution shall disclose to the defense all photographs, video, and audio recordings or other tangible objects in the constructive possession of the Commonwealth, provided it is relevant to the case. The metadata underlying the Canton Police Department Sallyport Garage video is clearly a relevant tangible object in the constructive possession of the Commonwealth. By the way, lawyers are always behind the times, and what's a tangible object and what's not when it comes to technology is something that bar committees meet everywhere on and try to figure out exactly what's considered tangible and what's not. But generally speaking, we want to turn over discovery in these cases to criminal defendants. We're not going to write rules that keep things that could be relevant and admissible and potentially exculpatory from criminal defendants, because that is a problem. That is a problem. Cheswick said, can we create a poll as to whether there will be overtime tonight or not? I know my guess, but Kelsey, go ahead. Write a poll and say, will we need overtime to get through these documents tonight? Yes or no? And let's see what the people think is going to happen. But you're not going to slow me down, Cheswick. Okay. In short, by simply, did I miss that? The metadata underlying the Canton Police Department Sallyport Garage video is clearly relevant, tangible object in the constructive possession of the Commonwealth, which directly bears on the accuracy, authenticity, and reliability of critical surveillance video evidence in this case. In short, by simply dragging and dropping files from the Canton PD's video file system to a USB, the relevant metadata necessary to verify the accuracy, authenticity, and information associated with the creation and storage of that information will be destroyed. You don't need to be a rocket scientist about this stuff. Even I understand what metadata is. Even I understand why doing things a certain way destroys the opportunity to prove something was doctored, right? Because it's going to all start over and rewrite every time you do something like drag and drop files onto a USB port. There are forensically appropriate ways to download, to move, to alter, to do anything with evidence that is as important as this, especially as has been highlighted by the defense throughout the entirety of this case. Moreover, The defense rejects the notion that there was an agreement by all parties regarding the proposed procedure for obtaining the additional Canton Police Department Sallyport video in the possession of the Commonwealth. The defense was misinformed regarding the source and import of the additional Canton Police Department Sallyport videos during its initial conversation with the Commonwealth, i.e., the defense was led to believe that a retired detective's work cloud account or computer may have a copy of one, some, or perhaps none of the videos, and then were later informed by the Commonwealth via email that the evidence at issue was the Canton Police Department's video file system. Upon learning of the correct source of the additional Canton Police Department Sallyport footage, the Canton Police Department file system, the defense immediately objected to the procedure proposed by the Commonwealth. An agreement by necessity requires a meeting of the minds by all parties. As it relates to all material facts that did not occur here, indeed, yesterday at 3:30 p.m. on Friday, February 28th, 2025, after the issue was litigated before this court, the defense received, for the first time, a report from the Commonwealth dated February 27, 2025, from Sergeant Paul Giampietro, maybe something like that. Nice Italian boy, right? Detailing an after-the-fact chronology of his purported handling of the Canton Police Department video surveillance footage in this case. So here is the new information. According to this new report, which was not produced by the Commonwealth until after the hearing on this issue, Sergeant D is claiming that he was responsible for downloading all of the video surveillance footage from the Canton Police Department in this case. According to Sergeant D, he downloaded certain of these videos, including the inverted video, onto what he refers to as the detective drive. That detective drive purports to contain the critical video surveillance footage at issue, which will be presented by both the Commonwealth and the defense at trial. The defendant has a constitutional right to obtain and present evidence relating to the authenticity of this video surveillance, the authenticity of which, as set forth in defendant's motion to compel production of a forensically sound copy of the January 29, 2022 video surveillance footage in law enforcement custody, is of critical importance in this case. Special Prosecutor Hank Brennan has been in contact with Sergeant D for months. This information should have been relayed to defense prior to litigating these issues. As explained by the defense expert and computer, IT, and mobile device forensic analyst Matthew Erickson, if the Commonwealth has an individual simply drag and drop, a person, I was thinking individually simply, has an individual simply drag and drop these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. Here's what this tells me. Here's the new information to me in my brain. Here's why I don't think it's going to get any better for the Commonwealth when it comes to these videos. I don't think very many people over there have a clue how to, either that or they're incredibly smart in how they're trying to set all this up to destroy, any tracks of what's going on. But either they have no clue how to do all this techie stuff, or they're doing stuff to purposely not leave a footprint. By the way, will we need overtime? 83% of people say yes, 17 say no. My guess is no. I think we'll be able to do this in an hour, but only time will tell. The fact that we are here in this case with everything that's been complained about, everybody has to agree that the trickling out of video is not good, even the Commonwealth, even the judge. And you know that the defense is making this an issue. The defense has asked for it. Now, whether they asked for it on February 2nd or not, who knows? Maybe, the Commonwealth still, not who knows. I believe they did ask for it. The Commonwealth has an argument as to why they think they didn't ask for it. Fine. All this technicalities and argument going back and forth. There is no doubt in anybody's mind that right now, these videos, the snippets, the blurriness, the parts that are there, the parts that are not, the way they've been handled, the way they have or have not been turned over. Everybody knows this is a big issue. Everybody knows that this is an issue that needs to be handled above board, and that this is an issue that needs to be handled perfectly with everybody on the same page, because accusations will be made by the defense that you did something wrong and you did it wrong on purpose. Everybody knows that's a thing at this point. And yet they still continue to do things like this. They still continue to simply have a guy drag and drop them into this file. Either the guy doesn't know what that's going to do to the metadata, or he does know and he wants the desired result. Either way, it's problematic. And to me, with all eyes on them dealing with these video surveillance footage, all eyes on it. Everybody knows this is going to be a problem, and they're still doing it like this. To think what they did before, when maybe it was going to be a big deal, maybe it wasn't, maybe people knew about this, maybe they didn't. That, to me, shows that back then it's just going to be a mess. If we ever get down to it, if anybody can actually answer those questions that I would love for them to answer, the answers are not going to be good for the Commonwealth. There's just no way. It's got to be, I don't know, somebody else did it. This guy who's retired and doesn't know how we do things here did it. There's not going to be a clean and straight answer. I don't foresee that happening. When the judge is reviewing and making decisions on these motions, does she make the decisions alone or does she consult with other judges? So she makes the decisions for her alone. That doesn't mean she can't consult with other people, right? So maybe that answered your question, maybe it didn't. It's not like a group of judges get together like an appellate court and make a decision together. This is her decision to make. Every judge has their own docket, their own cases. But from time to time, judges ask their friends or colleagues that they trust, hey, what do you think about this? Let me bounce this idea off of you. And they can have input from other people, but those people have no decision-making power in her case. How outrageous are all these varying video stories? They're not good. And to a certain jury, they will look horrible, right? But to other jurors, they may just be like, okay. Lauren Bell, can you retroactively produce a chain of custody? Theoretically, I guess you can and say, this is what we did, and I'm going to swear to it. But it opens you up to cross-examination where it's like, why did you wait 3 years to do this? There's more funny business here. So, it can always be cross-examined and there can always be issues later. Christy, intentional or not, I wonder what else could be on the detective's drive that has never been turned over or in a paper file that went missing. How do we as the defense, how much would that scare you if your life was on the line? Where we just are finding things now 3 years later in paper files. It's like, hey, Hank and law enforcement, can you guys check the other paper files too? Because maybe there's something in there that could be helpful to my case. Maybe something else exculpatory ended up in a paper file, right? I don't like those types of explanations because they leave open the possibility for other just poorly done or negligent explanations. Netwoman, dumb question, I doubt it. Did investigators take any picture of the vehicle before tow? They say that they did, I believe. You're asking me a very specific timeline question. I know there were pictures taken of a vehicle. I can't remember if they were before or after tow, but I know that a law enforcement officer testified it was cracked before tow. Wouldn't tow document exterior before tow? By the way, since I've missed so many lives, I think it's going to be double overtime. Just kidding. Thanks for doing this tonight. Double secret probation. So what happens if the videos get thrown out? Better for defense or Commonwealth? So that's a good question, Janet. And I don't know who they're better for, right? I think both sides can use them and both sides will say, this is what we see on the video, whether they actually see it or not. And it's going to be up to the jury to use their own eyes. But what's interesting about this is neither side is trying to get these videos thrown out. The defense is not using these motions to say, we got to throw these videos out because they believe they're exculpatory. So I don't think they're going to get thrown out if nobody's asking for them to get thrown out. You feel me? All right. That will remind me of the ASAP Rocky trial. Let's get back to this motion. As explained by the defense expert in computer IT, I already read that. The proper forensic protocol for preserving this critical information and obtaining the relevant data is as follows. A forensic image should be made of the operating system drive, as well as additional drives where these video copies may be stored, if stored on something other than the operating system drive. The operating system drive is critical in this situation, as it will provide key information about the handling, modification, and creation of these video files. Without a forensic image of the operating system drive, all independent and forensically sound verification methods would be impossible to perform. And by the way, when I said even an idiot like me when it comes to tech can understand that you can't mess up with the metadata, I'm not saying I fully understand everything this guy's saying, right? That's why you need experts like this to explain how it works. And a judge needs to say, okay, We can't screw up key evidence, especially if it's exculpatory. And we have to understand that it's important to do things the right way. But if you have experts that disagree on how something should be done, that's where it becomes difficult. That's where it becomes difficult. Additionally, any relevant dates that are present in the available metadata would reflect the dates that the most recent copies were created. And now the actual dates on which the initial copies of these video files were made for the forensic drive images we request that they are uncompressed, unsegmented, and preferably in raw DD format. I don't even want to try to get into this specifically. I'm sure people can argue back and forth in the chat about, what's important, what's not. But I think we can all at least agree that the date something is created is important. And if you create a clip that's part of a whole and you cut it out and create it, and that has a different date than the original clip, well, somebody's doing stuff, right? To dumb it down to my level. And these experts need to be able to testify to that. In light of the information detailed in the supplemental affidavit of defense expert Matthew Erickson and this new report authored by Sergeant D, defendant respectfully requests that this court reconsider the portion of its February 18th order denying the motion to compel and order the production of this information as is required by Massachusetts Rule of Criminal Procedure 14 and Ms. Reed's constitutional right to present a defense and to confront witnesses against her as guaranteed by the Massachusetts Declaration of Independence, Article 12, and the Sixth Amendment to the United States Constitution. Absent this court's swift intervention, the defendant will suffer irreparable harm. Okay, now let's go to the supporting affidavits. First, Matthew Erickson. I, Matthew Erickson, hereby do depose the state. I'm an IT expert. On December 11th, I traveled from Phoenix, Arizona to Boston to render an expert witness services in the case. The purpose of my trip was to allow me to extract surveillance video from the Canton PD in a forensically sound manner that aligns with the methods accepted and commonly used in the digital forensic community, as well as review any video footage presented within the system from January 29th. 22, I visited the Canton Police Department on December 12th. So what's interesting about this affidavit is I do think they all need to have these affidavits. All that is very important. What's frustrating to me is she didn't make the Commonwealth have an expert come out and say, we're doing everything the forensically sound way, right? The judge, if she's going to say that it's all done fine and it doesn't need to be done the way that the defense says is forensically sound, can we at least get an expert for the Commonwealth to say drag and drop is fine? And you can still get all this information drag and drop. At least if you're going to make that call, hopefully an expert will tell us that will work out fine, and then we'll see. After photographing the relevant DVR equipment, I began recording the audio and video and then accessed the system. Initially, it appeared to me that there were only 30 days of video history and consequently that the relevant footage had not been preserved. That impression was confirmed when I navigated to the appropriate section of the DVR system where I searched by day and time could be performed, and I ran a search for January 29, 22. That search returned 0 results. We already know all this. The way the CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of original surveillance video data. The CPD's DVR system, like most, stores videos on a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then the data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Due to the Commonwealth's failure to preserve the original surveillance footage, I was unable to extract the DVR system footage from January 29th. Even though that had previously been arranged by all parties, I am informed the Commonwealth may have additional video surveillance footage from January 29th that's being stored on a separate electronic device, known as the Canton PD's video file system. It is imperative that this additional source of information be preserved and dealt with in a forensically sound manner, as it may serve as another source of information relating to the authenticity and integrity of the video surveillance at issue in this case. Once again, I don't care if this is Karen Reed or John Smith. We know this stuff is important, okay? So please don't do stuff with any of the video surveillance without everybody agreeing. And the Commonwealth can act like, oh, these pesky rules, it's so annoying. But It just has to be done right. Nothing in this investigation has been done right. So if we're finding stuff now that's evidence that's going to be used at trial that's important and relevant and material, let's handle it appropriately to make sure it can be in the proper form to be used at trial by either side that may need it. If the Commonwealth has an individual simply drag and drop these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. The proper forensic protocol for this, okay, and then he goes through that again, which we already read, and it's sworn to on the 2nd day of March, which was yesterday, by Matthew Erickson. The amount of work, I cannot overstate the amount of work that is going on in this case. And this is all while the defense is prepping for trial. And while they should be just prepping for trial and not dealing with all of this. All right. Supplemental affidavit of Elizabeth Little in support of the defendant's motion for reconsideration. I represent Karen Reed. The facts are true and correct. Attached here to is Exhibit A is a true and correct copy of February 27th report by Sergeant D. I didn't find that attachment anywhere. Thank you, Ashley, for sending me all these documents, by the way. I didn't see that. I don't know if it is public. I don't know. I would love to read that report and just see how he's handling the evidence even now in February of 2025. Can we learn anything from how they handle the evidence now? I think we can. Based on the new information submitted to the court for the court's consideration, I respectfully request that this court allow defendant's motion for reconsideration of a portion of the February 18, 2025 court order denying the defendant's motion to compel. All right. That's the last affidavit for that. Now we're going to go to their motion for clarification. Thank you to everybody gifting memberships tonight. See a bunch of people gifting the memberships. That's always awesome. Love to have a bunch of new members join. Thank you, Netwoman here. Clarification regarding the statement in defendant Karen Reed's opposition to Commonwealth's motion to exclude motion 4 to exclude employees of ARCA. Either a typo by them or by the Commonwealth in the original motion. Now comes the defendant Karen Reed and files this instant supplemental affidavit of Elizabeth Little clarifying the following statement, which was included in the defendant's opposition to the Commonwealth's motion 4 to, so that must be what the Commonwealth titled it. And so she's keeping the title in so we can know exactly what they're responding to exclude ARCA, which I prepared and filed. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. To be clear, the defense did not hire, retain, or pay ARCA LLC to engage in the reconstruction, analysis, and or testing that was performed by ARCA in connection with this case. By the way, when we talked about this and everybody was like, oh no, will they still use ARCA? Is it going to seem like they paid ARCA? How can they still talk about ARCA? Well, the answer is, this is what you can still say. And that's what we said before. Whether you pay them to travel, whether you pay them to prep, all of that can be understandable to the jury. But what we didn't pay them for is we didn't initially hire or retain them. We didn't have anything to do with the reconstruction analysis or testing. And we had nothing to do with their initial report. Somebody else hired them and paid them to do all of that. And they can always say that because it's the truth. It always has been the truth and it always will be the truth. But we need to make sure to stick to the truth because she follows it up. The defense did, however, reimburse ARCA for the following time and expenses after trial and after the defense received the ARCA invoice dated July 12, 2024, which was provided to the Commonwealth in reciprocal discovery on February 20th, 2025, prior to filing the opposition. 1. Travel expenses and time associated with traveling to Norfolk Superior Court for the voir dire and trial in this matter. 2. A total of 0.75 hours, less than an hour, in calls with the defendant regarding coordinating attendance at the voir dire and trial and discussion regarding the experts' backgrounds. So that's almost nothing. I don't care if it was 10 calls. If the totality was 45 minutes, You're not prepping them for what they testified to in 45 minutes. Number 3, time spent testifying in court and the expert's internal preparation for the voir dire and trial testimony. So it wasn't just trial prep, it sounds like. It was actually their time for testifying. I give a lot of credit for the defense for correcting the record and making sure everybody knows they did pay them for travel expenses, time for prep, and time testifying. Now, if I want to quibble a little bit and how, lawyers are still trying to couch things in certain ways, I have never in my life ever used this terminology or even heard anybody use this terminology, but to reimburse ARCA for their time, right? Lawyers get paid hourly a lot. When you bill your time and then you get paid for the time that you billed, I have never heard of anybody personally calling it being reimbursed for their time. Usually you're reimbursed for money you spend, like you buy a plane ticket and you are reimbursed for the receipt that you paid out for the plane ticket, and the time you spent working, you're paid for, right? So if you want to quibble, I'm sure people are going to say, oh, look at them, they're still lying. And it is what it is. And I wouldn't have used that terminology personally. Yes, Ashley, words do in fact matter. And that's a weird way to couch it. And I think they probably couched it for that way that they wanted to. To be frank, if it was paid in retrospect, it was kind of reimbursing. I couldn't disagree more. Okay. And this is where we got to keep things on the straight and narrow and be intellectually honest, right? I've never heard of anybody being reimbursed for time that they billed. You're paid for time you're billed, right? Again, we can disagree, can agree to disagree. That's just my perspective. So reimbursed makes it clean, paid for sounds shady. I guess, I don't know. But yeah, it's not something that causes me grave concern, I don't think. Not me. But again, you can understand why people take the issue that they take and lawyers use the words that they use. Okay. The defense did not know what, if any, wink, wink, expenses they would be responsible for covering until after the trial in this matter concluded and they received instruction and guidance from the U.S. Attorney's Office. And this right here is the ticket. This is what makes it great. That's the great piece of evidence. And frankly, if I was the defense, I would say, Judge, I don't feel like we can give this answer properly in front of the jury without saying we first called the U.S. Attorney's Office, and the judge is going to be like, no, you can't mention that. It's like, well, Judge, we feel like that's the only way to give the full context around our payment. If they really want to be difficult as the defense, then they can be. So taillight confetti, why does it matter? At the time they were asked, they had not paid them anything. 100% agree. What they said in court, absolutely true. At the voir dire, at the hearing, at the trial, 100% agree with you. I'm with you. At the time they were asked, all experts are paid for their time and travel to testify. 100% with you all the way till the end of this statement, except for the why does it matter? Why did they use that verbiage? Why didn't they just say we paid them for their time and reimburse them for their travel? Which to me, nobody can quibble with. And I agree with you. It doesn't bother me one bit. I pay experts in every one of my cases. Not me, but our firm and clients pay experts in every case we have. I agree with you. There's nothing nefarious about that. And what they said in court was true. They hadn't paid them at the time, but we all know they've paid them now. So let's stop acting like it was just reimbursing for travel expenses. I think that's where, like, when you start to try to create gray areas when there isn't a gray area, it opens up people to argue with you about something. I don't think the defense needs to argue about this. Peter, if they paid for it out of their own pocket, then it's reimbursement. Do you think they paid for their own time out of their own pocket? Like, do you think Dr. Wolf was like, well, Dr. Wolf billed $500 for this hour, so Dr. Wolf's going to get his checkbook out and write Dr. Wolf a $500 check? I don't think that's what happened. I guess theoretically you could be right. I guess if that's how it happened, then he would be reimbursing him for paying himself. I don't know. I don't think that's what happened, if I'm being honest. Reimburse makes sense. They don't pay before they come to testify. But that's just not what reimbursement is. And you pay experts after the fact. You pay all sorts of hourly billers after the fact. And I'm not aware of it ever being called reimbursement. But again, all you guys in the chat, if you feel that it is, then okay, it's fine. Compensate would be a perfect word. I compensated them for their time that they billed and worked. People should get compensated for their work. just a mom. They were reimbursed for their costs, including lost wages. So I do know that is 100% not the definition of lost wages. I do argue for lost wages in lots of my cases. That's not the definition of lost wages. Interesting though. I like the comments and I like the disagreement back and forth, even if it's a disagreement. And that's the end of this affidavit, but we have more coming. I wonder how many laws and bills will come from this case across the country. Let's not repeat the Karen Reed case. Speaking of that, at some point I do want to talk about, I've been hearing, I don't know, I haven't seen any official documents, the whole like $75,000 for Hank Brennan, and now it looks like he's going to make over $200,000. In my brain, I'm like, that makes a lot more sense. If you're a private criminal defense attorney and you're going to shut down your practice to handle this case for a year, 75 grand is just wild. 225, 250 grand. Okay, I guess I can understand why somebody would do that. I still would never do that. Now maybe he has associates and his firm is still running, but people are outraged about it. To me, it only makes sense. And I think, again, just like this reimbursement word, I think that whole $75 or $75,000 thing was trickled out there so people wouldn't get mad about how much he is being paid. And so people wouldn't get mad at, you have all these lawyers and you have all these government lawyers that you're paying, that people's tax dollars are paying. And yeah, and Hank Brennan's being reimbursed $225,000. That's pretty wild to me. That is pretty wild. I don't necessarily have a problem with it. I think a lawyer's time is worth that. And I think there's a lot of work on this case and it's really hard. And we have heard about the $5 million billed by Karen Reed's team. But from my perspective, why was it pitched and couched the way that it was? Why do you guys think? Started watching you for law videos, sticking around for pickleball videos. New court looks like a fun time. It's amazing. And there's more pickleball content coming. I can't wait for you guys to see the one next week. I died when it happened real time. And the Kelsey's edit made it even better. Nikki, how does the Commonwealth even have a leg to stand on to object to this when they originally agreed to the defense's expert come out to get the original footage in the first place? I think the Commonwealth is just like, hey, they're going to say everything we do is wrong. And so we shouldn't have to do it the way the defense says. Our experts know how to do it, et cetera, et cetera. At this point, it's starting to feel like everybody's objecting to everything, which is never a good spot to be. Thank you for your coverage, Salt Life Girl. This case has been incredibly frustrating. I've learned so much from your channel. Side note, my son just got accepted into Florida State. Yay. Is he going? Because guess what? My nephew's accepted into Florida State, and I'm going up there with him this weekend to do his official tour and try to recruit him, take him under my arm, and he wants to be a lawyer, and he may have a firm he wants to come work at. I'm like, you got to go to Florida State. If you want a job, you got to go to Florida State. Not fully, but kind of. JC, can the defense revisit their motion to be reimbursed for their IT expert since the videos are supposedly held on a physical system? They can try. It seems like she's already made her decision for that. But as new information comes out, which this new information, anytime you get new information, you can file a motion for reconsideration, in my opinion. Chris K. Peter, CPD is going to use a new high-tech device to save the videos called a floppy disk. No, what they're going to do is they're going to take out their camcorder and they're going to film themselves scrolling through the video on the computer screen. Thank you, Netwoman. Another 20-bagger of memberships. All right, another supplemental affidavit from Elizabeth Little, which was just about the clarification we just read. The facts set forth in the opposition filed are true and correct. The statement called into question by Special Prosecuting Attorney Hank Brennan at the last hearing was poorly worded and should have reflected more specifically that the defense did not hire, retain, or pay ARCA to engage in the reconstruction, analysis, and or testing that was performed by ARCA in connection with this case. I love it. I love number 3. Correct the record when you can. Also, if you remember the rules of professional responsibility, the ethics rules for lawyers that were cited, as long as you correct anything that you said that was wrong, you're fine within the rules and you should correct them as quickly as you can. And as soon as Eliza Little found out about this stuff, she files this motion, files this affidavit. So any wrongdoing that came from a misstatement, an inaccurate fact, is now setting the record straight and correcting the record. You may not like it. You may still want to call them liars, but Hank Brennan did it in court where he said, Judge, I want to make a correction. It wasn't the feds that sent me this. It was the defense. Eliza Little does she go by Eliza? Somebody must have said Eliza, and I say it all the time. If she goes by Elizabeth, I apologize. She comes, she corrects the record, totally appropriate. And to me, within the rules of professional ethics, let's move on. Let's get this case to trial. Let's all act ethically and responsibly and do things that are right so we can have a just result at the end of the case. Kay Willis, thanks for gifting some more memberships. I personally edited and was responsible for filing the opposition to the Commonwealth's motion to exclude employees of ARCA. The opposition, which included the phraseology, was drafted by a law clerk, and no other attorneys worked on this opposition. So besides an unnamed law clerk, she is falling on the sword herself. It was me, myself, and I, Judge. I'm setting the record straight. And now you got Yannetti, Jackson, and Little, Alessi being like, everybody does something different, Judge. So how are you really going to attribute these two inconsistent statements potentially to the same person? ARCA paid their employees, defense getting reimbursed by ARCA. No, it's not how it works. Tons of experts have employees that they bill, whether they pay them hourly or not. And by the way, I would be surprised, and very rare is it that the ARCA pays Dr. Wolf what Dr. Wolf bills to the defense. What actually happens is Dr. Wolf bills 10 grand to the defense pays 10 grand to ARCA, and then ARCA gives Dr. Wolf 6 grand or something. And ARCA takes their cut for managing, for having all the insurance, for connecting lawyers with experts. And usually that's how those groups work. It's not like ARCA paid Dr. Wolf 10 grand and then they just get reimbursed that same 10 grand. Again, I don't know. I'm just guessing and giving you my experience and what I've seen, how it works in other similar situations. Yes, my son is going to FSU, and congrats to your nephew. So exciting it is. It's really hard to get in there now. So that's a really good accomplishment for your son, for my nephew. Proud of him, proud of your son as well. And he won't regret it. FSU is amazing. And if he ever needs anything, you've got my email. So give it to him. I know a ton of people still in Tallahassee, and I'm there all the time. Anything I can ever do or questions I can answer, happy to do that. Johanna Kate, what if the invoice was payable to ARCA, not Dr. Wolf? Wouldn't that be reimbursement if not paid, if ARCA paid the doctors first? So people are thinking, they got their thinking caps on, and they're trying to argue for a position. I like that. I love it. I want some more of it. I just disagree in this situation that was a reimbursement. I could be wrong, and I could be corrected, and maybe one of these comments will change my mind. As I sit here, and I do a lot of this type of work, so maybe it's the way that I understand in my experience. Maybe they call it reimbursement in Massachusetts or California. I just don't, in my opinion, anywhere that I've ever done this. Netwoman, 10 more. That's 50 memberships gifted by Netwoman in this live. She's trying to make it go overtime, I think, because every time it's just a little bit longer, a little bit longer, a little bit longer. All right. We have one more document to get to here. At least that I have. These are the documents I have. There could have been more that were filed. I had a crazy smashed packed day today. So it's possible I missed some stuff, but Ashley, here she is, did a lot of research for me and sent it my way. Thoughts on what Bev should do, and then what you think she'll actually do, because we all know she's not going to punish the Commonwealth. See, here's the problem. I think that this video stuff, no matter what the defense gets at this point, is not going to be in great shape. It's not going to be in great condition. It's not going to be usable. So they're still going to have these arguments. So how much is she going to, make everybody bend over backwards to get the same result? I don't know. If it was me and I was the judge, I would say, Commonwealth, give them every single thing. Let somebody sit there or share your computer screen. It's this new thing you can do, that you can share your entire computer screen and have the defense expert and whoever's doing this for the Commonwealth sit there and record it. You can also record what you're doing on your screen the entire time for everything they do to manipulate it, to look at the metadata, look at when stuff was created, edited, whatever. Order them to do that together, for all of that to be saved and potentially be used at trial if it becomes an issue. I have no idea what she's going to do. She's probably going to take a path of least resistance and say, Commonwealth provided to the defense the best she can. And it is what it is in defense. If you want to argue it on cross-examination that something bad happened or they did something nefarious with this, go for it. It's going to get lost with all the other problems in this case that the defense has to argue. And that's what's frustrating, right? We've talked about the keep it simple, stupid. We've talked about that's what the defense should do. They should simplify this case. They should do X, Y, and Z. It's easy for me to sit here and say, oh, this is what you should do for your closing argument. But there's just so much to go through. There's so many things that don't make sense. So many things that are illogical. So many things seem like they're done in the shadows. We're just not done like that how you do it in every other case. Not following proper protocols and procedure, that it can't be simple. That's the rub for me on this case is the defense needs to keep it simple, stupid, right? They just need to keep it simple. We all agree on that. Keep it simple, but they just can't because it's so complicated. And so you can't miss important things by keeping it simple. So they've got to figure out how to toe the line of simplifying it, but not losing all of the important details. That's their job. That's why they get paid the big bucks, or I should say, that's why they bill the big bucks. Didn't Karen Reed call Eliza in this morning's video? That's a good point. Maybe that's where I got it. Reese's mom, and that'd be a good source for what her attorney's name is, right? Thank you, Harley Chick, for gifting a membership. Okay. Commonwealth's Notice of Discovery 60. A copy of the MSP report number 108 dated 2/19/25, 32 pages. Again, I don't have this case memorized. Maybe you guys know what each one of these is. If you want to throw it in the chat, like number 28 is this, and we can talk about it more. There are some that are obvious. A copy of Lieutenant Tully's notes to MSP report number 108, 1 page. So that was 2/19. Okay, so that's the report after the last hearing. Copy of Dr. Crosby's addendum to the report dated 2/19. Okay, so their experts addendum to the report, which is additional information. We'll see if that comes up in a future motion. And again, as I read this, I can't help but think to myself, yes, I can't help but think to myself, everybody hit that like button. But I can't help to think to myself how annoying this is as the defense. They're supposed to already be done with their discovery. We're within a month for trial, and they're still turning over new discovery. More things I've got to respond to, more things I've got to read, more things I've got to prep for experts, more things I've got to give to my experts and pay every time there's a new document you want your expert to look at, guess what? Maybe some of them are doing it out of the kindness of their heart. Maybe some of them are doing it at discounted rates or pro bono, fine, whatever. But from my perspective, you got to pay your expert. Every time you give them a new piece of paper, a new email, a new video, a new thing to look at. And that's annoying. All of it's annoying. Christy said, my son also got into FSU. Well, we got an FSU party here, and I love it. I'm all for it. A copy of the transcript of unredacted Gretchen Voss interview. Okay, that's good. We knew that was coming. The Commonwealth has it, so they are giving it to them, even though they previously gave it to them a couple days ago. And again, another copy of the Gretchen Voss interview. Copy of an email to Special Prosecutor Hank Brennan, dated 2/23. No idea what that's about. Copy of email to Hank Brennan, dated 2/6. Copy of email to Hank Brennan, dated 2/26. Copy of email to Hank Brennan, dated 2/26. Copy of email to Hank Brennan, dated 2/17. These are probably, he said, they get tips. People are trying to help him, and he turns over all of this stuff to the defense whenever he can. Azam, Peter, if this goes to trial and still ends up in hung jury, do you think a third trial will be held? I see here reimburse money. Can't imagine how much taxpayer money is used. Everything the Commonwealth is doing points to, yes, they would try it a third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th time. But I would think the defendants will file some speedy trial motions if this goes a third time, that this has been overhanging. She's been held in jeopardy for too long. It needs to get dismissed. They'll have more motions each time there is a mistrial. And the public will be outraged every time there is a mistrial, as they should. But like I said, it's up to the Commonwealth at the end of the day. I always was like, why would someone ever defend a Como until I watched your YouTube, a criminal, I think you mean, or maybe a criminal accused, until I watched your YouTube and court TV. Now I understand even a despicable human deserves a defense. So maybe you mean legitimate criminals. And thank you for this, I Am Groot. This makes me feel great that even if you think they're horrible human beings and they get what they deserve, and when people are convicted and do horrible things, they deserve horrible sentences. But I appreciate it that you are starting to understand why it's important, how our country's set up, why it's, still, people can argue with me, it's still the best criminal justice system in the world. And we have a lot of international people that will attest to that from how things are done in their country. But I appreciate it. I love when people tell me the purpose of this channel, to learn about your rights, learn about the system, become a part of it, know how important your voice and vote are and these kinds of things, and not just for president and whatever, but for judges, for prosecutors and people that appoint prosecutors or appoint judges, how important all of that is. So I appreciate anything that comes out like that. So thank you. Does this ARCA situation cause tension between the defense now? Not between the defense lawyers, I don't think, and I don't think between ARCA and the defense. If you want my honest opinion, this is totally a guess. I think it brings them all closer together. When you deal with difficulty and you're on the same time and you got a common enemy, now I feel like if I was ARCA, I'd be like, let's get these guys. You know what? You don't have to pay me for trial number 2. That's what I would do. I'd be like, we're going to get these guys. They think we're shady. They're calling us liars. They think we're doing stuff under the table. We're not. I'll make sure the jury knows you didn't hire us initially. Because ARCA, frankly, if they were more in bed with the defense, as some experts are on one side or the other, they could have gone a lot into more detail about, yeah, I did all this work. I did all these experiments. I did all these testing. I came up with my report. My final thought and opinion on this case was locked in before I ever talked to you about this case. I don't care what you want to happen in this case. I'm not asked to do anything by you. I don't care if you pay me or not. You're not paying me for an opinion. My opinion is what it is. I answer to a completely separate agency that is not Karen Reed. What happens to her, happens to her. I care about justice and all that, but I'm just here to do a job, and that car didn't hit that guy. They could have been even more pushing in that way, and they really weren't. They were pretty just answering the questions they were asked. Who cares who paid them? The FBI hired them. It's important. If the defense paid them, our rules of evidence allow, the United States and just about every jurisdiction, the rules of evidence allow you to say you were paid $23,900 whatever dollars by the defense in this case. And if they want to get into this much was for travel, this much was for prep, this much was for trial testimony, that's fine. They're able to do that. But that is a question that is relevant and allowed in every trial from every expert that I've ever been a part of or seen. All right, what else did they turn over? Copy of email to prosecutor, copy of email to prosecutor, copy of email to prosecutor. So this was an interesting one. Copy of voicemails for special prosecutor. So this could either be just like a Scrivener's error, a typo, or it could mean something different than an email to Hank. This is a voicemail for Hank. So maybe it just means, somebody called for Hank Brennan and left a voicemail, 2 audio files. Again, tips. maybe it's something, maybe it's not. I don't know. So I would just assume these are voicemails to Hank Brennan. Copy of MSP report number 109, dated 2/28. So again, I think this might be Sergeant D's report, but think about it. This case is going on still. It's 3 years old, still new reports, still investigation happening, still people working to put this case together. Copy of report 110 dated 2/28. Copy of Canton Police Department report dated 2/27, 1 page, 5 new pages of reports. Copy of reproduced Bates stamp NDAO 2390 to 2395, which was previously provided on 1/30/25, subject to protective order filed on 1/31. So new information, new documents for the defense to deal with, all coming less than 1 month after the discovery deadline's closed, I'm pretty sure, if I remember correctly. Good luck. Here you go, defense. Go ahead and deal with it. And we don't care if you want to strike any of this stuff because most of it's good for you. Now, the defense may be late on stuff too, and they may have no choice. We've already heard they want to push back the motion to dismiss because they need more time to respond. I haven't heard if the judge gave an answer to that. Is it a gray area if the Fed said they can't be hired, but they are available? Wouldn't you assume that you can't pay them? Maybe that's why it's considered a reimbursement after the fact. So I agree with a lot of the first part. Is this case is just different. It's weird. I can believe the defense didn't know if they were going to have to pay them or not. I can believe that. I would have assumed that probably was going to have to pay. But the word reimbursement, right? And I had a feeling this was going to strike a chord. The word reimbursement just does not make sense to me in the way that they used it for the time testifying. Azam, I understand that the first trial is behind us, but can the defense bring up that there is still new discovery now for second? Why didn't they turn it over in the first? Can it be used for reasonable doubt? So there's differences, right? Reasonable doubt to the jury is different than discovery violations. It's not going to be reasonable doubt to the jury, but it could be if they withheld evidence that should have come in trial 1 and they just turn it over now, theoretically it could get the case dismissed because they didn't turn it over in trial 1. So yes, theoretically it could. I don't think it's going to. Kelly Kell, I am a 2L and watching you makes me feel better about taking breaks from my memo. Getting some great PR hypos too. Thanks for being a fun professor. Well, Kelly Kell, I appreciate that. Never been anybody's professor before, so that's cool. I love it. If I could teach in my own way, maybe it would work, but I don't know. I don't know. I've never been like in really a professor in a school setting before, but I love it. And real life stuff helps so much because they teach you how to think and how to read and look at stuff differently in law school. They don't teach you how to practice, and there's not a lot of practicality to it. So I think real life examples are an amazing way to learn. I wish this stuff was available when I was in law school. I for sure would have watched trials, learned how some of the best do it. So that's great. And the fact that you do tells me you probably got a leg up in a lot of people in law school. Where do you go to law school? I'll try to check the chat and see if I can see it afterwards. Congratulations, 2L. You're done with the worst year, but the bar is the worst part. The Racine. What about tensions between the lawyers? Would you be frustrated if you were David Yannetti? Are they upset with one another? So it could happen. I just don't get that feeling. I don't think so. I think they are together. I think they're all together. And I think Yannetti, if he, so chomo is a real thing. I don't know what that is. So sorry. That happens all the time where I don't know what a chomo is or a word is. But yeah, I don't feel any tension between these defense lawyers. I really don't. I think they're working together as a team. I think they like working together. I think there's a mutual respect. That's my vibe. I could be completely wrong. I didn't get that same vibe in some other trials that ended up coming to light that there maybe wasn't fully love on lawyers all on the same team. Where is the spell check? Wow. Yeah, I'm not a great speller, so spell check is a very important and great thing. And my paralegal is amazing at it, and I always tell her, I'm like, thank God, because I'm not good at that stuff. Ashley Rhyme, welcome to you and all of the new members. All right. That is the last document I have. We are 52 minutes in, well within our 1 hour. No overtime tonight. Hit a like for that. We kept our video under an hour. Mark, thanks for the coverage, Peter. I appreciate the thoughts on the cases. And also, I am not Ron Burgundy, so I will not read something off the teleprompter or super chat that I do not agree with or despise. Actually, it's not true. I do read a lot of things I don't agree with. I try not to read things I despise like that, Mark. Reese's mom, since the Alberts got to whine on the stand about harassment, can the ARCA guys be asked about their family's harassment? Theoretically, yes. I don't know if they'll want to, but also we talked about that during the trial. And I said, jurors could take it either way, right? They could feel bad for them, or they could be like, oh, what are they talking about? Or maybe they really did do something bad. Seems like they felt bad for them about that. So, oh gosh. Thank you. I am Groot for telling me what that actually means. I don't think it's like as obvious as maybe you were saying. So, but thank you for telling me. I mean, thank you for not actually spelling it out on the super chat too. Oops. Oh, why would I put that one up again? No, there was a new video. I don't know what that means. I don't have it. So this is all I got. So feel free to send it to me. We got plenty of time left this week to break down everything that's coming out with the hearings and new documents. The special prosecutor, Brennan's paralegal, hate him. I would say no, but I cannot know. You guys are the best. I appreciate it. Hit that like button on the way out. Come check me out tomorrow and the rest of the week. Make sure you're subscribed and hit that reminder bell. Love hanging with you guys, whether we agree or disagree. Always try to learn something. I hope you do too. That's all we got this time. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.